So, just like we say for ordinary witnesses, laymen, women, the cross-exam of an expert is optional. You only cross-examine if there is need. If there is need. You see, it may very well be that based on your case theory, what this expert has said has zero effect or impact on your case theory. Zero. Nothing adverse to your client's story has been said by this expert. Now, I always give this example of, say, a criminal case. A criminal case of assault, or a criminal case of murder. When your client pleads not guilty, the charges are read out to them, the accused person pleads not guilty. The accused person is saying one of two things. The accused person is saying, A, it wasn't me. I did not do it. I wasn't there. In fact, I have an alibi showing I was 500 kilometers away. It wasn't me. I did not assault that fellow. I did not did not kill that fellow. That's one thing. Number two, by pleading not guilty, the accused person could be saying, yes, I did the act complained of, but I have a complete justification, legal justification for what I did. Therefore, I do not have the requisite guilty mind. You see? So, the accused could be saying, I acted out of self-defense, I was provoked, and I was intoxicated, I was suffering from some mental incapacity of some sort. And all those are defenses recognized in law. Now, if you are defending this accused person whose story is, it wasn't me, I wasn't there, I did not do it, and the doctor comes to produce the P3 form to say the injury is sustained by the complainant, do you have any business as a defense counsel cross-examining that doctor? Do you have any business? Zero. Absolutely none. I mean, as far as your client is concerned, whatever injuries were sustained is none of their business. I'm not the one who did it, so I don't care about the extent of the injuries, or I don't care. I did not do it. But if your defense is provocation, self-defense, then there you might have every reason to cross-examine that doctor on the extent of the injuries, with the aim of tending to show that the injuries were not so bad. They were consistent with self-defense. You see? So the decision to cross-examine an expert is a fundamental decision that you have to make based on what your story is. I mean, you are acting for accused number 4, the offense is robbery and causing harm. Your client, accused number 4, was the taxi driver who drove the getaway car. All he did was to park outside the building where the other thugs were doing the job, and then he drove the thugs away. That's all your client did. And it's not in dispute. Even the prosecution, they are saying accused number 4 drove the getaway car. And of course, you are equally guilty. You could be equally guilty of the offense of robbery as an accessory after the fact. But as a driver of the getaway car, you are now the lawyer of this fellow. Do you have any business cross-examining the doctor on the injuries sustained by the fellows inside the building where the job was being done? Do you have any business? No. You have no business. All you did was to drive the getaway car, and you didn't know that these guys were thugs. You are innocently doing your job to earn a living. That you are not part of the gang. You see, so the decision to cross-examine is critical. Having made the decision, then you must do it right. And we indicated last week that there are at least 5 areas that an expert can be cross-examined on. Nobody is saying you must cross-examine on all of them. No. Qualifications. You can point out in your cross-exam that perhaps this guy is not really as good an expert in this area as he holds himself out to be. For example, you have this case where it's a personal injury case, and the most significant injuries sustained by this plaintiff were orthopedic problems. And the doctor that who has come to testify here as an expert is only a general physician. It's not an orthopedic surgeon. So you could say to the doctor, you're a general, you're a GP. Yes. You are not an orthopedic surgeon. No, I am not. Full stop. You have finished. You have finished your cross-examination on that aspect of qualifications. Nobody is saying that the fellow is not a doctor, a qualified doctor. Yes, they are, but perhaps having regard to the specifics of the case we are dealing with here, an orthopedic surgeon would have been a much better witness or expert to deal with this issue. That's all you are saying. And in your closing argument, you can comment on that. See? So qualifications, as we pointed out last time, can be acquired through formal classroom learning or through experience or a combination of both. And all those things can be challenged. Number 2, an expert witness can be cross-examined on independence, interest, impartiality. If you have information based on your research, you see, you're not just coming to cast aspersions on people. You have concrete material. You have concrete information suggesting that this expert is not independent because they have some relationship with a party to the case. They have a financial interest in the outcome of this case. They have some whatever connection, personal, professional, whatever, that this guy only testifies in support of big pharmaceutical companies. You've done a bit of research and you have seen this fellow hops from one cough to another, and all they do is to support big pharma, big pharmaceutical companies. You can point that out. There's nothing wrong with it. You say, Doctor, you testified in the case of, yes, in support of the plaintiff, yes. In the case of this, you testified in support of the defendant company, yes. In this case of, you testified in support of the defendant pharmaceutical company, yes. Full stop. You are finished. You see? So impartiality can take all manner of dimensions. Impartiality can come about because of so many reasons: personal relationships, financial interest in the outcome of the case, bias based on whatever. So you can bring all those things out, and then in your closing argument you can say that perhaps the testimony of this guy shouldn't be taken so seriously because of this aspect of impartiality. So when cross-examining the fellow and you have brought out all those aspects tending to show impartiality, you don't then ask the witness, kumbe then that is the reason you have come here to testify. Hapana, wachana na hiyo swali. Wachana na hiyo swali. Of course, the fellow will deny it. That is material for your closing argument. You don't say to the fellow, so it is obvious that you only testify in support of pharmaceutical companies. The fellow will say, look, I am a professional doctor. I testify when I am called to do something, and I do it, and then I give my professional. So you have ruined your whole... You see that? If the re-examiner can find a way of remedying the damage done by the cross, well and good. Well and good. That's their business. You do yours. Number 3, you can challenge assumptions. Assumptions made by this expert in doing whatever it is that they did. Typically, when experts do whatever they do, they proceed on the basis of certain assumptions. And assumptions are accepted. Assuming that those assumptions sometimes could be faulty, could be misleading, could be the assumption made was wrong, with the consequence that even the outcome of the entire process is then erroneous, because the assumption made wasn't based on very sound footing assumptions. Number 4, you can challenge the methodology employed by the expert in doing whatever it is that they did. It may very well be that the methodology employed in carrying out this task is outdated, obsolete. Science has since moved on. There are better ways of doing this. There are much more advanced methods of doing this kind of job with better results. This older way of doing things has been shown to be prone to giving us bad results and so on. So methodology employed can be challenged. And finally, even the conclusions themselves, the professional opinion rendered by this expert itself can be challenged. You know, because as we said last time, the expert is not God. The expert can give some erroneous opinion, either inadvertently or deliberately. I mean, experts do all sorts of crazy things every day, either for personal gain or whatever. You know, fear of reprisals, whatnot, political correctness, and whatever. I mean, the world is full of such. So, even the conclusions reached can be challenged. I always give the example here of this guy who, in the early 90s, was the chief government pathologist here in Kenya. The man is dead, so we can talk about him freely now without any fear of being sued. Dr. Jason Kaviti. Dr. Kaviti examined the body of the late Dr. Robert Ouko, who was the Minister of Foreign Affairs. His body was found in February 1990, someplace in Koro, Kisumu, near his rural home. Now, obviously, the chief government pathologist was involved in the post-mortem and all that. After a while, the president at that time formed a commission of inquiry into the circumstances leading to the disappearance and death of Dr. Ouko. Now, during that commission of inquiry, which was led by 3 prominent judges, Dr. Kaviti did advance a suicide theory. Believe it or not, that the good old minister may have committed suicide. You know, in the face of information already produced showing that the good old minister had all his bones broken, all of them, shot through the head, and the body burnt using petrol. Now, the good pathologist, Dr. Kaviti, under cross-examination by the lawyers there, could not explain the sequence of events. You know, how the good minister went about this suicide business. Did he do the shooting first, the breaking of the bones first, the lighting of the fire first? What was the sequence of events? The whole theory was torn to shreds because it was nonsense upon stilts. It was absolute nonsense. One of the judges there remarked that Kenyans were lucky that Dr. Kaviti dealt only with dead people, not living humans, because his way of doing things wasn't so good. As to whether he is resting in peace is not for us to judge. Our Lord is a merciful Lord.